to New York City. I'm going to call the session of the Public Service Commission to order. Secretary Burgess, are there any changes or additions to the final agenda?
Good morning, Chair and Commissioners. There's no changes to the final agenda.
Thank you. So this morning, we have a number of items for discussion. The first item is item 201, and it's a number of related cases, including the matter of eligibility criteria for energy service companies. It's going to be presented today by Kim Harriman, our General Counsel. Welcome, Kim, and please begin.
Thank you, Chair. Good morning, Chair and Commissioners. Item 201 is a draft order that, if approved, would reset the landscape for the residential and small commercial retail market within 10 days of issuance of the order. Further, it would direct record development regarding that market, and it would tighten enforcement tools. Back in 1998, the Commission embarked upon the development of both the wholesale and retail marketplace. Specifically, with respect to retail marketplace, the Commission determined and set forth protocols and rules to allow customers to obtain their commodity supply from somebody other than the utility. The companies that step forward to provide this commodity supply are known as Energy Services Companies, or ESCOs. Those markets were open for large and industrial customers as well as large commercial customers, and for mass market customers, which are comprised of residential and small commercial customers. With the opening of these markets, the Commission established rules for operations for ESCOs known as the Uniform Business Practices. Those rules were originally established in 1999. Periodically, since then, the Commission has reviewed the status of the market and the sufficiency of the rules. Today, we have over 200 ESCOs that operate in the state. One of the reviews the Commission embarked upon was in case 12M0476. This docket was open to review the operation of the market, particularly with focus on mass market customers. In that docket, the Commission evaluated the ease of price comparison for customers between the ESCO commodity offerings and the utility commodity offerings. It also questioned the ability of commodity-only products to be competitive with utility commodity-only products. Lastly, it recognized the value that was already being received and continued to be received by industrial and large commercial customers. And it called on parties and staff to define and to better understand value-added services when, in fact, in 1998, when the Commission opened the marketplace, it was envisioned that such services would be coupled with commodity supply, but that product's niche, value-added in addition to commodity, had failed to materialize. The Commission took subsequent steps, both in 2014 and 15 orders, that changed and enhanced price transparency requirements. It improved marketing rules, and it provided price protection for certain low-income customers. Specifically, out of the docket 12M0476, the Commission required independent third-party verification for ESCOs that were enrolling customers for door-to-door telephonic marketing. It also required ESCOs that were serving assistance program participants. These are the customers that receive utility low-income discounts, and to basically have the ESCOs guarantee to that customer sector that those customers would pay no more on an annual basis than they would have paid if they were a full-service utility customer, or that the ESCO would be providing that customer a value-added service. It directed staff to work collaboratively to define what is meant by energy-related value-added products and services. Subsequent to that, the Commission opened a docket 15M0180, which, among other things, specifically focused down on the rules for ESCO eligibility and standards. In that docket, the Commission reviewed a number of possible new rules for ESCO's eligibility, including additive requirements for ESCOs with high complaint rates, improvement plans for where there has been high complaint rates, as well as a consideration of, in cases where ESCOs received a high level of complaints, whether or not the revocation of their eligibility should occur. Staff additionally recommended tightening down of enforcement periods. Specifically, they recommended that the cure period, in this situation, if an ESCO violates a UBP provision under the existing rules at the time, the ESCO had an opportunity to cure the violation and proceed with business. In that case, staff recommended that the cure period be shrunk to basically 0 for ESCOs that had a repetitive failure of UBP violations within a 3-year period, or where the violations themselves were egregious enough to warrant more specific and direct action. So a couple of factual observances, both from the 98 case as well as the 12 docket and the 15 docket. What we have seen is pretty significant, and that is one, and it should be clear, that the ESCO community is providing value to industrial and large commercial customers. The dockets and the ample record have demonstrated that. 2, that there appears to be significant and severe deficiencies with respect to the operation of the retail market for mass market customers. Again, this is the residential and the small commercial customers. With the steps taken by the Commission to continue to ratchet up enforcement and to tighten requirements for operation, we have not seen a corresponding decline of customer complaints, meaning that the customer complaints continue to persist at a serious and significant level despite the enforcement tools and rules put in place by the Commission. We've had advocates, consumer advocates in both dockets recommend that the Commission take steps to eliminate the residential market and the small commercial market in its entirety. We've had advocates, numerous comments on the fact that ESCO customers are being significantly overcharged in comparison to the utility full-service customers. Right now, we have a vast majority of ESCO customers that are serving mass market and only commodity service offerings. They market to customers through both door-to-door telemarketing and direct kiosk operation, and this marketing takes a significant amount of capital by the ESCOs. Because there's a low likelihood that an offering from an ESCO of commodity service only will be able to ever beat the utility price, we are seeing complaints that are mirroring this reality. For example, in 2015, the Commission received approximately 5,000 initial customer complaints. Over 1,000 of those complaints were escalated complaints. The makeup of those complaints comprised about 30% that dealt with questionable marketing practices. 25% involved dissatisfaction of prices, no savings, and 22% addressed slamming. That is when an ESCO enrolls a customer without the authorization of the customer. So the state of the land is this, that the nature of the ESCO retail market for residential and small commercial customers on a commodity-only basis is simply not working. The complaints demonstrate that, and our own anecdotal evidence that have been amassed from 98 forward demonstrates that there is very little to no value being provided to residential customers in this commodity-only market. So the draft order before you finds that it is no longer in the public interest for ESCOs to provide commodity supply only products for mass market customers with certain exceptions. Specifically, within 10 calendar days from the date of this order, enrollments of mass market customers or renewals of contracts with mass market customers will only be allowed for ESCO products that provide guaranteed savings for an annual period as compared to the utility commodity service, or that the commodity provided by the ESCOs represents at least 30% of energy from a renewable energy source. Moreover, for customers renewing from a fixed or guaranteed savings contract, the draft order would require that any ESCO switching from that contract to a renewable product offering obtain affirmative customer consent. So ESCOs who have customers who are rolling into off of a fixed or guaranteed price contract into a green product to be compliant with the order, the ESCO must obtain customer consent for that transition. In addition, the draft order would require CEOs or their equivalent corporate officer to make a filing within that same 10-day period certifying that any enrollments that were provided to utilities as of the 10th or 11th day of the order, would have to comply with the order. So they're going to certify, in fact, that their products will be in compliance for any enrollments that are provided to utilities after the 10-day period. Now, during the 60-day period, the draft order would have additional record development regarding the long-term conditions that should be implemented for ESCO eligibility and conditions for service to mass market customers. To that end, the Commission could continue the criteria as set forth in the order that enrollments would only be allowed for customers that are receiving a guaranteed price product from the utility or the ESCO as compared to the utility, or a at least 30% green product. But the Commission could also look at and add or modify those conditions after the 60-day record development period. And that could include consideration of a marketplace that would have commodity plus value-added services being a qualified product offering for an ESCO to provide to mass market customers. To this end, a notice would be issued providing this more granular review regarding the long-term conditions for market operation, and specifically the notice would posit whether or not these conditions should be modified, how we would define energy-related value-added services, whether or not there should be an extension of a 3-day waiting period for customer rescission on contracts. This speaks to the component, that complementary side of this, which is enforcement and customer protection. And right now, there's a 3-day period in which the customer can rescind a contract. Should that be longer? Should the customer have a longer period of time to do more research and analysis? In addition, the notice will solicit comments on whether or not ESCOs should provide performance bonds or demonstration of financial capability so that they can follow through on their commitments and promises to customers, especially as you have this requirement that they provide guaranteed savings. The last thing we want to see is that customers pull up stakes at the end of the annual period because they can't provide guaranteed savings, and then the customer is out that money. So we really need to look at how we make sure they have financial stake in the game. Lastly, the notice would solicit comments on whether or not the Public Service Law's provision regarding penalties found in 25 and their provisions should be applicable to ESCOs. Currently, the Commission has not rendered an opinion on the applicability of PSL 25. PSL 25 is a penalty provision that allows the Commission to assess through civil court proceedings $100,000 a day against any regulated entity that has been in violation or is in violation of a Commission order. That is a tool that has been useful and used by the Commission, and it should be evaluated as to its applicability to the ESCO marketplace. With respect to enhancement of enforcement, the draft order before you takes the staff's recommendation on shrinking the cure period and goes one step further. Specifically, it would allow the Commission, through modification of the UBP, to proceed directly to an order to show cause route. An order to show cause is issued that would call on an ESCO to respond whether or not their actions warranted either a revocation of eligibility or some lesser appropriate response. Right now, as we talked about previously, there is a cure period where the ESCO can, if found to be in violation of the UBP, make corrective steps and proceed in marketing and operation. The draft order would have the UBP modified so that no cure period would exist for even one violation. So there's no pattern of violations or no serious or egregious violations that need to take place. The Commission would say, one strike and you're possibly out. It is a tool that is to be used at your discretion, and it's not a mandatory response as far as revocation of eligibility or proceeding to order to show cause with only one violation. But it does provide a more direct and immediate response for the Commission to employ where warranted. Lastly, one of the things that we've seen over the past several years is a pattern of high complaints that will, when you look down into the weeds of these complaints, they may not necessarily rise to the level of a UBP violation. They are serious enough and significant enough that you have to question whether or not that ESCO should continue operating in this state. The draft order before you would also allow the Commission to take action as appropriate, whether it's revocation of eligibility to operate or some lesser action, to address ESCOs that are having very significant complaint rates on a historic basis and a going forward basis. In addition, the UBP would also be modified pursuant to the draft order before you to allow the Commission to consider any violations of federal, state, or local sales or marketing regulations or failure to respect the no solicitation signs to be basically a violation of the UBP. So right now, there are rules of engagement out there in municipalities with respect to door-to-door marketing by any entity. We expect the ESCOs to comply with those rules. In addition, we expect them to comply with signage in businesses that say no solicitation. Failure to respect both these rules and the signage clearly posted would be treated as a UBP violation and could have subsequent consequences, including revocation of eligibility to operate, as well as any lesser appropriate response. Both the change in the marketplace, the landscape, the refining of the offering to only be those that provide savings as compared to the utility commodity offering, as well as the 30%, at least 30% renewable product offering, as well as the other enhancement tools with respect to marketing practices door to door, are all well and good, but we have to make sure that we're on top of this in auditing. And to that extent, the draft order reflects the direction to staff to audit the ESCO records and to ensure that these enrollments that occur post the 10 days are compliant with the order. And to that end, we will be formulating a team internally that is comprised of not just OCS, but it's a multidisciplinary team with experts in auditing to take on this task. That concludes my remarks, and if you have any questions, I'd be happy to answer them.
Thank you. And I don't want to neglect the fact that in addition to Kim, Michael Corso and Luann Scher are here too, and also available to answer questions on this matter. So, you know, I was thinking about this order and realized that almost, I think, from the first day that I arrived at the Commission in 2013, we've been talking about ESCOs and ESCO challenges. In fact, I think it was the first conversation I had with Commissioner Sayre, because it was something that he was deeply involved in. And I know that this has been a matter of great concern for the Commission, not just beginning in 2012 when the Commission began this proceeding to take a look at the mass market for ESCOs, but actually well before then. And since then, Commissioner Akampora has certainly reminded me that this has been one of the most frustrating aspects of her tenure at the Commission. There's clearly, I think, as the Commission said in 2014 in their order, when we talk about the mass market, and I think as Kim has said, we're really talking about the residential and small commercial. We are not talking about the large commercial industrial where people actually have the ability to negotiate good prices for themselves. The market simply is not a competitive market, and I think what the Commission found in 2014 definitely holds true today. When we think about competitive markets, it's not just about having multiple suppliers. It's actually having customers with the type of information so that they can command the ability to make decisions that help them. The problem we have in the retail commodity market when it comes to residential and small business customers is that it's a really obscure product. People really don't, you know, they understand electricity in the sense that they understand they want lights. They understand gas in the sense that they understand they want heat. But to really start understanding what it means to be a kWh price and what's fixed and what's firm and what's comparative is very, very difficult to people to understand. And that's why when the Commission looked at this and staff looked into it in 2012, and when we looked at it again in 2014, what we found is that the prevalent practice for residential customers and small business customers that they were paying more for this commodity than if they stayed with the utility. And so when you combine the fact that really people don't have the information necessarily to make decisions, so it is not a competitive market, and the fact that we have an obligation to offer just and reasonable rates, the fact of the matter is that when people are paying 2 times, 4 times, as much as 8 times more than they would get if they bought it from the retail utility, that's not just and reasonable. And we simply can't tolerate that kind of behavior. The other thing that I think is remarkable is the fact that this isn't ancient history. This is, in fact, we look back and staff to receive some information that is January 2016, this past month. National Grid customers paid $17 million more in 1 month for energy from ESCOs than they would have paid if they just stayed with National Grid. For some customers, that was an average of $29 more in 1 month per customer. We fight major rate cases over those types of issues. The fact that people are in this position is simply intolerable. So, that is really the fact that, that alone, I would say, is a problem. When you take that on top of some of the practices that we have seen in this industry, and people have seen the videos, and we hear about these stories, and Luann and Michael tell me all the time about the various things they hear about, it's really horrible. You have people who don't speak English very well, maybe new immigrants, being preyed upon to buy products. We have salespeople telling people that their utility is not going to sell them electricity anymore, so they have to buy from them. We have people coming in and saying, oh, I work for Con Ed, buy from me, and it's not true. And then we have people who don't even know they're changing providers and find out later that they've been switched. I mean, and I wish that I could say that we took care of that, and we did issue a lot of changes in our rules in 2014 to address those problems. And I've talked to a number of ESCOs and retailers, and I know that my fellow commissioners have done as well. And I hear from a lot of retailers that they want to offer real value to their customers. They want to offer green pricing. They want to offer energy efficiency. But the problem is that there are still way too many people who are out there not offering real value, and as a result, customers are suffering. And so we have to act. I don't think that it's sort of, we just can't simply say, well, let's find and fix the rules again. So that's, I think, where we are. In terms of that, I think the Commission has done a number of things. We've made the rule changes that Kim went through in 2014. We put in place a consumer advocate. We told our consumer advocate we wanted that he and his team to be aggressive. I think we've done a number of changes. And as again, we've gotten assurances from a number of ESCOs that they would like things to change. But, simply saying people want things to happen and making them happen, I think, are two different things. And we really need to take some action. I'm aware that we've heard from a number of consumer advocates that we should simply shut down the market, that they think that's the best thing to do. They're at a position where I think they think that there's no good to be had here. I can tell you that I personally am not there. I still very much believe in markets. I still very much believe in innovation. I think with the right products and the right rules, New York can lead in this space like we lead in so many other areas. And I think it's really up to the Commission to really put those into place. And we do see glimmers of this. There are a number of companies who are offering green products where they're really offering renewables that not just at the mix that we have in our resource pool in New York, some as much as 100% green, and we want those kind of products to continue. I see a number of companies who are looking to offer energy efficiency products, but we have to define how those can be offered and how those can be priced. So in the meantime, I look at it and I believe there are really three paths that the Commission could take. The first path that a number of the consumer advocates offered was simply shut down the market. Simply say, for the residential and the mass market customers, full stop, doesn't work, we shouldn't allow competition anymore. The other is the process that the Commission has been using, which is basically to take a look at our rules, tighten them up further, see what other problems that we could take out of the market, and continue to use moral persuasion, nagging, revocations as a way to persuade people to get where we want to go. I don't think that, at least for me, I don't think we can take that path anymore. The third, which is really, I think the appropriate one, is the one that's being recommended in this order. And what's being recommended is that we take very decisive and very bold action and be very clear on what we will allow and what we won't. And so to do that, and again, I'm not going to try to rephrase everything Kim said, but I want to be very clear. we think that clearly if a retailer wants to come in and offer guaranteed savings to customers, that should be offered. We want that to happen. We've already done that for the low income. There's no reason why we would ever want people to be deprived of an opportunity to save money. Never met a customer who says, I want to pay more for electricity or gas, but many people would say they would like to pay less. So if they can do that, great, let's do it. The other is to say if a retailer wants to come in and is able to offer a product that is renewable based and is more than the 26% that we already have in our mix, so it's a minimum of 30%, and they can guarantee that, we want them to do that. The other piece that I think is going to be equally important is that over the next 60 days, we're going to be working very, very hard to define those additional products that could be offered and will provide value to customers. This is not a stop of the market. It is not even a moratorium. What it is a full stop is let's get out the bad stuff. Let's bring in the good stuff and be very clear on what we want so people have the guidelines and they can construct their businesses accordingly. The other piece that I think is very important is something that I know that Commissioner Berman and Commissioner Akinpora have talked to me about, as well as Commissioner Sayre, is the fact that we may have been too tolerant. We may have been allowing people to say, oh, I'm really, really sorry, I promise I won't do it again, and then we let them go on. Well, we can't do that anymore. If there's a problem, if we find a violation, the Commission wants to hear about it, and we'll make the decision whether that company is going to continue to operate in the state or not. We might want to make it absolutely clear that no New Yorker should be in a position where they're finding themselves paying more for electricity because they were deceived into buying a product they didn't want, or they were deceived into thinking they were buying from someone they didn't even know, or they felt that there was a nice name and someone promised them that they would have savings and they didn't get those savings, which is just not going to happen anymore. So while I know this is disruptive, and I know that for many of us, we'd like to see the markets go, we want the markets to blossom, that sometimes for government, it's nice to guide and say this is where we would like to go. But sometimes you have to be disruptive in order to break things a little to make them better. And I think in this instance, with what this commission has done, what the staff has done to try to get people, the companies, to a position where they were offering value, the fact that they were not able to police themselves means that we do need to make decisive action, and to do that today so that we feel better than knowing that no further New Yorker is ever going to be put in a position that so many New Yorkers have found themselves in. So I feel very comfortable about the order. I think we're on the right path. I think we will get the retailers where they need to go, and I fully endorse it. So thank you, and I thank the staff for doing such a good job on this decision. Let me I'll turn to Commissioner Akinpora.
Can I say amen to what you just said? Here we go down memory lane again. I've been here a long time. This is something that's really very important to me. Luann, we've gone through story after story after story, and I consider myself the queen of flexibility. We've been flexible to the point of where the flexibility just isn't working anymore. And so I wholeheartedly agree with this order. And Kim, you mentioned about one strike and you're possibly out. I love that. That's something I've been waiting to hear for a very long time. It is our responsibility to protect consumers. And, you know, how many times can you keep going back to the UBP and trying to make it into something that really works? We haven't really been successful in doing that because consumers still need protection. And so I believe that this order will address that. And, you know, you stated in the beginning of your summation of this, we have over 200 ESCOs in this state. Other states have, maybe you can count on 1.5 hands, and they're large states too. And so to whittle this down, we know the commercial and large industrial has been very successful, but we wrestle with residential and small businesses. And we wrestle with the fact that because New York is such a diverse state, and because we do have people of many ethnicities that are here, that are coming here, do not speak English or understand English well, that sometimes some of these companies, this is where they prey. They prey on low income, they prey on people who are new immigrants, and they prey on the elderly. And this just is not acceptable in New York. So I will wholeheartedly support this measure.
Thank you. Commissioner Sayre?
This is a very serious step we're taking, but we're addressing a very serious problem. The mass market for ESCO services is simply not developed, as Chair Zibelman said, in the way we hoped in terms of savings combined with energy-related services. Economically, it seems pretty simple to me. For an energy-only service, how can you expect ESCOs to beat the utility rate, the default rate, on a consistent basis, where the ESCO, but not the utility, needs to make a profit on the transaction, and where the ESCO, but not the utility, has a high cost to acquire each customer through marketing and sales, and both the ESCO and the utility are buying the energy in the same wholesale market. Now, maybe somebody's got a secret sauce. That's the American way, and if they can guarantee savings, that's fine, and our order provides for that. But for the most part, the data show that the market is not working, that the non-green energy-only market is not working for New York consumers, and it's our job to look out for those consumers. So I support this item wholeheartedly as well. I'd also ask the staff to take a look at the issue of violation of do not call laws. Do not knock laws are mentioned in the order, but the order is broad enough to cover do not call laws on both the federal and the state side. And I must say I've received some ESCO calls illegal because I'm on the do not call list, and I bet a lot of other people in this room can say the same thing. So congratulations, this is a good order.
Commissioner Berman?
So I just have, before I make my comments, I have a couple of questions just to make sure that it's clear, especially because I think people are listening in and making sure that they understand while we await the order. Can you walk me through what we'll be doing in the next 60 days and what the expectations are for the ESCOs in going forward once the order is issued?
Thanks, Commissioner Berman. So the first thing we're going to be doing is reaching out to the ESCOs to talk to them about the requirements that are going to be put in place 10 days post issuance of the order. So as we've discussed, the ESCO enrollments that happen after that 10th day have to be for products that guarantee a price savings off the utility commodity service rate, and or have to be at least 30% renewable product. The order has language in it that is instructive to the ESCOs about how to tailor their product offerings to ensure compliance with the commission order. And as always, I don't think there's an ESCO in this state that doesn't know Luann Scherer. We will be engaged with them, and in a good and not so good way sometimes, but but we
Lucky Luann.
we will be engaged on all levels within the department with the ESCO community to help facilitate their transition to this new product offering. In addition to that, so that's the near term. How do we get to day 11? How do we get from here to 60 days is this. There's going to be a notice that's going to be issued, and it's going to posit a series of questions. Some of these questions are going to require ESCOs and the stakeholder community to more granularly focus on, for example, the definition of energy-related value-added services. That was a task that was given to staff and the stakeholders out of the previous orders of the commission, and I think folks tried and maybe didn't put a wholehearted effort into getting to that definition. Well, they sure as They will now, let's just say. Because that's another pathway that we can come back to the commission to say this too can be an eligible product that can be offered by an ESCO to a mass market customer. So I think it has to be an open dialogue and communication, because there are ESCOs out there that are good ESCOs. They want to operate as a value to the residents of the state and the small businesses, and so we want to work with them to facilitate that. And as the chair mentioned, there's many ESCOs who are already compliant because they're offering a green product that exceeds even the 30% standard the commission has set forth in the order if adopted.
When we talk about the 30% is per customer, not globally, correct? Okay, and what about door-to-door marketing?
So door-to-door marketing is not being prohibited by this order. What the commission does with this order is basically say in the UBP, you have to comply, ESCO, with federal, state, and local laws with respect to door-to-door marketing and with any signage that is posted. What we found through a review of the complaints, especially some of the small business customers, and as Commissioner Akampora mentioned, the ethnicity issue of not having English as a primary language, that we've seen ESCO marketing door-to-door to those kind of ethnic small businesses where there's pressure tactics, there maybe is some deception, and so we want to ensure that if those businesses post no solicitation signs, whether it's at a small business or a resident, that they're respected by the ESCO. Just like Commissioner Sayer mentioned the do not call list, it's a do not knock list, which we want to ensure that if the ESCO does not comply with those requirements or the signage, that could be treated as a violation of the UBP and under the one strike and you're out rule acted upon by the commission. So door-to-door marketing is still going to be allowed under the rules that have already been set out in the UBP and as now tightened if adopted in the order with respect to respecting both laws and signage for no solicitations.
Okay, thanks for that clarification. So when we have no new enrollments unless guaranteed savings or 30% for customers renewables, who makes the determination on what the green product is?
So part of the work that we're going to have to do over the next 10 days, maybe working some weekends in there, but is to ensure that the ESCOs understand whether or not their product is compliant with that 30% requirement. And we have some detail in the order that I didn't go over that's pretty specific about how to be compliant, but it's going to have to be a dialogue. More importantly, and I just want to make this point because I think it's a good one to make, we're not asking the utilities who receive the EDI transaction to enroll to be the policeman of this, to second guess whether or not that enrollment I just received is providing a compliant product. But what we're going to do, and that's the last point in my presentation this morning, is we're going to have an audit function. We're going to go in and we're going to assemble a multidisciplinary team in the department to go out and to audit any CEO or corporate officer is certified that their product's going to be compliant and we know they're going to operate in the market post day 10, we're going to go out and audit on a regulated or regular schedule basis. We may not get to every 200 ESCOs within the first day, but we're going to go through them and audit them to make sure they're compliant.
I just want to add, because I think this is important. So I do think over the next 10 days, because we don't want folks to inadvertently be out of compliance simply because they didn't quite understand it. So I do think the order, I know the order contains what would constitute a green product. What I have asked staff to do is to get with the ESCOs, provide a guidance document, and so that way when the CEOs certify to us they're in compliance, they're certifying on the basis of a much more detailed document so they understand what they need to do to be in compliance, so there's no surprises and there's no obscurity about that. And I would fully expect that because the ESCOs are very familiar with our processes and our staff, that if there are any questions that they're not sure of, they'll be able to get them answered promptly so they're in the best position to make sure they know what they have to do to comply. And then, so that, I think that should, at least for folks who are wondering, well, what do I do tomorrow? That's what we're going to do, is make sure that people are really in that position. And then as we've noted, as Kim noted, I think it's important that we also very quickly do an audit to make sure that everybody is in compliance so that we don't find inadvertent failures.
Okay, great. And what about, so we're not touching existing contracts. What
That's
about
correct.
contracts that have a fixed rate and then go to a variable after month to month? Or go just month to month?
So-
Is that considered an existing contract or a new contract?
So it would be contract specific and how the contract is structured, and that's where that engagement with the ESCO is going to be really important. So I would recommend, and I won't give Luann's phone number out right now, but I would recommend that, I'm really killing it today. I would recommend that that's the kind of open dialogue we need to have where ESCOs can come in and say, look, I have this product or I have this contract, here's what it looks like. Help me navigate what's going to happen day 11. Specifically, any contract that's in existence is not being touched by this order. Any contract that is in a renewal situation, okay, some of these roll off after a certain period of time to month renewals, so they're automatically renewed. But that once you have that word renewed in there, you're triggering the provisions of the order, and so the requirements for the product offering would apply. But this is something that we're going to want to work hand in hand in, because again, our job isn't to frustrate the market and to eliminate it. It's to ensure that those who want to come and provide good products and savings to the customers are able to do so. So we're going to be working cooperatively with them.
Okay. And I know there was discussion on getting rid of the extensive notice and opportunity to respond and cure period. But I kind of look at that as there are times when an opportunity to respond and to cure may be helpful. What may not be helpful is if they don't cure and if changes don't happen. And just like how we're talking about not tripping up people who are, good actors, I do think that we should keep in mind that that process, that due process, which we've had established in the UBP and in our order to show causes, has been done as an instructive way of ensuring that we're working with them and not necessarily harming a good actor or customers, but actually trying to get at the crux of changing for positive forward action.
So let me just clarify. The modification, and Luann will tell me if I'm wrong, but the modification to the UBP that we're proposing in the draft order in front of you doesn't necessarily eliminate the ability to cure. What it does is it gives the commission a clear tool, and it puts the ESCO on notice that you may not be given the opportunity to cure. You may be taken right to an order to show cause. And I want to address your due process concern. The vehicle of an order to show cause is the ultimate in due process, because what it is it's an exchange of positions on the record before official action is taken. So due process is preserved by use of the order to show cause. But I agree with you. There are certain situations where an ESCO's behavior may not warrant the one strike rule. And that's going to be something we're going to have to work through. But it's important that ESCOs be aware that it could be a one strike. And that's where we're giving them notice now that they have to take seriously the requirements of the UBP. And instead of taking a process that may take us months to get to an action of the commission, we want to shorten that period of time. But it will be at the discretion of the commission. It's not mandatory, it's discretionary.
Okay, thank you. That's very helpful. When I look at this, I see we have a long history of having ESCOs in New York and working collaboratively with customers, with ESCOs, and with utilities. We have a Consumer Bill of Rights, we have a ESCO scorecard, and we have consumer complaint statistics that can give us a window into what we're seeing in terms of issues or concerns. And from my focus is in making sure that we don't, with a broad brush, paint everybody as a bad actor, but rather look at what we need to do to help in ensuring that we are going forward in a positive way. I do know that the legislature had in 2014, 2015 bills on telemarketing standards for ESCOs, which were vetoed, and there was a discussion on the need to focus on the Department of State and Department of Public Service and LIPA working together in looking at the telemarketing complaints. I just wonder what the status of that is.
So the veto message occurred on, I believe, November 30th. And the message requires that UIU, or Department of State, LIPA, and DPS refer violations of telemarketing rules to the AG. What we're doing at this point is we're reviewing all of the telemarketing complaints that come in. The call center or the consumer assistance group is reviewing all the telemarketing complaints, and we're flagging ones that we believe should be referred to the AG. We have not referred anything up to this point.
Okay.
However, I think, it is likely that this order, the draft order, if it's approved, will result in a significant decrease in the telemarketing complaints and all other complaints that we receive against ESCOs.
Okay, great. I'm going to wrap up in a minute. I just have one or two more questions before I speak on my comments specifically. But one of the things that I'm looking at is the focus on the environmental disclosure labeling, and knowing that we have a proceeding that's ongoing with that and working with NYSERDA. How does that fit here?
Yeah, so we're working with NYSERDA on what they call NIGATs, because we love acronyms. And that will become even more relevant as the Commission builds the record on CES, and we move into that vein. So, Commissioner, the Environmental Disclosure Labeling Program is the current program in place that will be used as part of the compliance mechanism, or basically informative to the ESCOs as to what would qualify as that green product. If the Environmental Disclosure Labeling Program is changed and replaced by NIGATs, which is out for comment right now, we would have that be the successor in interest to the Environmental Disclosure Program.
Okay.
So we're going to make sure that there's not a gap in any ESCO's ability to determine whether or not their product is compliant. And as we said, we're going to come back to you in 60 days, and I believe that should be one of the things we report back on, depending on where we are with the review and movement on the NIGATS reporting mechanism.
Okay, well, that's helpful. The uniform business practices constitutes the rules and practices that govern ESCO interactions with customers and utilities. Historically, the Commission has several times revised the UBP to reflect necessary changes, as the Chair mentioned. In fact, the Commission has, consistent with the provisions in the general business law, which deals specifically with energy services companies and their marketing energy services, including door-to-door sales, modified the UBP accordingly. So changing the UBP and revising it to reflect current practices and what needs to be done to move forward is not something that is unique in this situation. However, for each revision, modification, and change to the UBP or specific changes to the ESCO market, the Commission has traditionally enjoyed a rich history of significant collaborative processes with ESCO's utilities and consumer groups before any such changes were made. The two main goals have been to ensure consistency in standard operating practices for retail access and to ensure that all customers are afforded appropriate protections in dealing with their ESCOs. And our Reforming Energy Vision framework has incorporated the expectation that ESCOs and our third-party providers will play a significant and important part in achieving our REV goals. That has in turn initiated several proceedings to examine what is needed to have a thriving competitive marketplace and also to ensure consumers are afforded proper protections. In essence, that aligns with the two core goals that have been at the heart of the ESCO process at the Commission from the beginning. Again, to ensure consistency and standard operating practices for retail access, and to ensure that all customers are afforded appropriate protections in dealing with their ESCOs. We see this in pending matters such as Case 15-M-0180 in the matter of regulations and oversight of distributed energy resource providers and products, Case 15-M-0127 in the matter of eligibility criteria for energy service companies, and the various matters that seek to address low-income customer concerns, centering on the residential retail energy markets in New York State, not only with ESCOs but with utilities as well. And prior to any regulatory decision, we need to ensure we have properly established a robust record, ensure due process concerns are addressed, looked at unintended consequences from our actions, and ensure that we will have the tools necessary to properly implement our decision. I strongly believe that bad actors in the ESCO market should not be allowed to continue to do business in New York State, and we need to ensure that we have vigorous standards of operating procedures in place and that we provide proper oversight, guidance, and opportunity to improve performance such that we help to have a thriving marketplace that protects consumers. This includes addressing quickly when market participants exercise poor or illegal conduct. I am a little concerned about any unintended consequences of potentially halting virtually overnight in many respects residential and small commercial energy service markets to new customers without a drill down analysis on who the bad market participants are. Good companies with hardworking employees and happy customers can, in one broad brush, be grouped with the bad action of others. So for me, I look at the regulatory uncertainty and what the future holds and make sure that we are moving forward in a path that gets us to a place where the marketplace is one that's thriving and protecting customers. So I would like to ensure that when we do the report and the drilling down on the telemarketing complaints, that we really are looking significantly at all of the tools that we have and making sure that we're working, again, back to the rich history of these, historically focusing on a collaborative process with the ESCOs, the utilities, and the consumers and others that may be looking to come into New York to do business. I would like to see that we take a strategic, deliberative, and specific way of reviewing the current complaints and, where appropriate, bringing an order to show cause against specific actors, and after proper due process, imposing penalties such as revoking, if necessary, an ESCO's eligibility to sell energy services. I support coming back to the Commission within 60 days, and I do not support the Secretary being able to unilaterally extend the timeframes in this order, as I want to ensure the certainty in the Commission having it come back to us in that 60-day time frame and, taking a look at what we need to do. I do know that we do have an outstanding pilot program of community choice aggregation where ESCOs will be focused on that. And so for me, when we look at the pilot and drilling down on with a status of that, we should also be looking at how that is playing in the marketplace and with consumers and with the municipalities and what we may need to do there. So I do hope that this is getting us on the road of helping us to get to a place where we can feel confident in the marketplace and can feel confident that customers have the protections that are afforded in the UBP. And part of it comes down to our looking at what we need to do from an enforcement perspective, as well as looking at the certification and the recertification and the consumer complaints that are out there. So thank you.
Thank you. Just a couple of observations, and just what came to mind. One is that I'm aware, and I think we're all aware, that there are a number of retailers who've invested substantially in providing retail services to the mass market. And one of the, oft-quoted adages of business is that it takes 10 times more money to win back a customer than it does to lose them. And that applies whether it's your own customer or someone else. And one of the concerns that I personally have with Rev is this issue, is that we want customers to be willing to accept new types of services from vendors that provide them real value. One of my concerns is actually is the fact that is we have bad actors who make everyone feel that anyone but the utility is not to be trusted. Our ability to help vendors get into the market who are able to offer good services, we're just increasing their cost of customer acquisition. And so by becoming very firm on what can be offered, what can't, and operate, and acting very quickly, because I agree, I think with Commissioner Berman, I think we all agree, we want people to be able to get out there and offer real things of value as quickly as we can is something that this is about. But in order to that to occur in an effective way, we need to weed out the problems that are really plaguing this industry. And the other issue that I think is really problematic that we're going to have to address in this 60-day period is that even good players have a difficulty when they hire someone and that person is on commission and they are just trying to get the sale and they'll do it at any price. And so one of the things that I'm hoping that we can address during this period, because I agree with you, sometimes someone can just hire someone and it's just the individual, it's not the company, is how do we differentiate that? What kind of standards are we going to put in place to make sure that that kind of action doesn't happen anymore? So I think that this is, I don't want to say this is a glass half full, glass half empty, but I do think that by putting a full stop, it's not so much that we're saying we don't want competition. We just really want to be very clear about what products are not going to be offered and then what products can be offered so that we give companies an opportunity to build businesses that consumers will value. I think that is really the role that we can play to make sure REV becomes a very positive outcome for all consumers in New York. On the community aggregation, and we talk about this in the order, or the order speaks to this, that is actually an opportunity where we could see the mass market getting an advantage, and that is the type of activity that I think can happen, because what happens is that when you have enough customers aggregated, you can provide retailers to develop that magic sauce that Greg Sayre just talked about, where they can provide real value, where it's not just commodity but other services. And that's why I'm optimistic that these types of programs actually will get the mass market the same types of benefits that larger customers have historically had, simply because you get scale. So I appreciate, frankly, all the commissioners' comments. I know that this has been one of the most challenging topics that this commission has dealt with for a long time. But as I said previously, I think that we are taking the right type of decisive action to get this market right, and I do appreciate the work of the staff in getting us there. Sure.
I'd just like to go into the application of consumer knowledge and how we plan on getting some of this new information out to consumers.
So I think that's something we're going to be working collaboratively with the ESCOs over the next 60 days to think through. But I think it's an important issue, and we will be working with them, as we've always done in the past.
I know we have our consumer outreach people, and I'm wondering, they also have a lot of information when they're out there among the community. Will we be making anything new? And will we also have a no knock, no solicitation sticker for people? Because I'd like to get one of those myself.
I'll be producing that later on.
Okay.
We do have some ESCO-specific outreach material, which I think we're going to have to take another look at, depending on the results of the 60-day
Yeah,
collaborative.
because everything that we do won't work unless the consumers, we educate them.
Right, and one of the things that Michael does so great as a consumer advocate, and I'll toot his own horn for him, is
Good.
that he works with the consumer outreach groups. And
Yeah.
those are the groups like Pulp and AARP and other consumer-focused groups that really help us get the message out. And that's where we're, I'm sure Michael will be working phones and every lines of communication as possible.
Yeah, because it's really important that they have the tools to be able to make these decisions.
Michael, did you want something?
I just wanted to add, thank you, Kim, to Commissioner Heckenport. We have a Consumer Advisory Council that you're aware of, and we're going to have a March meeting to discuss this very topic with the members of the Consumer Advisory Council, so they can interact with us, ask questions, and understand where we're headed, and we'll work collaboratively with them so they can get messages and communications out to the constituents too. We use those networks effectively together, each
Yes.
other, to effectuate the changes that we're trying to work out, so we will be robustly working on that.
Glad to hear it. Thank you.
We can go on this, but let me, just the other piece too, is I think we do have the Power to Choose website. And one of the things that the commission identified in the Track 1 order was the desirability of really getting a standardized mechanism so people can compare. And I think one aspect of this order is maybe we can start now standardizing products, which will make it much easier for customers to compare across vendors. And, and I think that like many of our orders, will be one that the 60 days will identify maybe the first series of products, but then over time, we'll continue to add. And so as part of this process, I would hope in the 60 days, we'll define the process by which ESCOs can introduce new products that they think will be of value to customers that are beyond our thinking, because that's really what innovation's about. Anyway, I want to thank everybody for their patience on this, and unless there's something more, I'm going to move to a vote. So all those in favor of the recommendation to enhance enforcement provisions of the UBP and restrict ESCO sales for residential and small commercial customers to contracts that guarantee savings or provide at least 30% renewable energy supply as described today, please indicate by saying aye.
Aye.
And I concur, reflective of my comments at session.
Okay. And so 3 ayes and 1 concurrence, there being no opposition, the recommendations are adopted. Thank you very much, and thank you to my fellow commissioners for working with us on this matter. So while people are moving and to move things along, we're going to be moving to item 303, which is a petition for certificate of environmental compatibility and public need for the construction of transmission facilities in Cayuga County, and that will be presented by Judge Kevin Cazuto. Kevin, before you begin, I'm going to ask our audience, and I appreciate your attention. We all appreciate your interest. We do have a rule in this commission, though. We do like people to be able to see. So if you have a sign, please keep it at chest height, just so those behind you get to see our lovely faces. So, Judge Cazuto, can you begin?
Thank you. Good morning, Chair and Commissioners. This case concerns the joint application of NYSEG and National Grid for a 14.5-mile, 115-kilovolt transmission facility in Cayuga County and Onondaga County, and upgrades to existing facilities to increase electric transmission capacity in the Auburn area. The application was filed in May 2013. And the project is planned in 2 phases. Phase 1 is the new 115 kV line, which would run from the State Street substation in Auburn, traveling north for approximately 4.2 miles to its intersection with the National Grid existing right-of-way. From there, the transmission line will follow the National Grid right-of-way, generally east for 10.3 miles to the Elbridge substation in Onondaga County. Phase 2 would include modifications to existing transmission facilities in these rights-of-way to increase electric transmission system capacity in NYSEG's Auburn area. The Cayuga Operating Company owns 2 coal-fired generating units in this area, each approximately 150 megawatts. These units are located in Lansing. Cayuga participated as a party in this case. From January 2014 to June 2015, the parties engaged in settlement negotiations, and on June 22, 2015, a joint proposal was filed, which was signed by the following parties: the applicants, department trial staff, the Department of Environmental Conservation, the Department of Agriculture and Markets, Nucor Steel, the Sierra Club, and a citizen group identified as ratepayers and community interveners. Cayuga acknowledged the need for Phase 1 of the project, but opposed Phase 2 and did not sign the joint proposal. An evidentiary hearing was held on August 17, 2015, and on November 18, 2015, a recommended decision was issued, which recommended granting a certificate to the applicants. The proposed order concludes that the project is needed to address transmission system reliability and would grant the certificate. On December 11, 2015, Article 7 was amended to add a new finding regarding minimization of impacts to active farming operations. The proposed order addresses the new statutory finding. Some new property rights are required for this project. The proposed order concludes that the project is needed for system reliability in the urban area, and therefore finds that the extent of additional property rights required for the project has been minimized. That concludes my presentation. I'm available if the Commission has questions.
Thank you, Judge Cassuto. Any questions? I am certainly in favor of the JP. I think that the record in this case is abundantly clear. The transmission is needed. I appreciate the work of the company and the parties in addressing our concerns, that as we build transmission, we minimize the impact on local land use and try to maximize the use of existing rights-of-way. I certainly think the fact that we have consumer groups as well as environmental groups working with the staff and the company is indicative that we did find the right path, so I intend to vote in favor of this item. Any other further comments or questions? Hearing none, let's move for item 303, which is the petition for certificate of environmental compatibility and public need for construction of transmission facilities. All those in favor indicate by saying aye.
Aye.
Opposed? Hearing no opposition, there being none, the recommendation is adopted. So Judge Cassuto set a new standard for expediency. Thank you.
Thank you.
Good. We'll move on to the next item, which is item number 302. And this is a proposal for the continued operation of the Ginna Nuclear Power Plant presented by Judge Mullaney. Welcome, Sean. Please begin.
Good morning, Chair Zibelman and Commissioners. Item 302 is a draft order that would adopt the terms of a joint proposal filed by Rochester Gas and Electric Corporation on October 21 of 2015. The joint proposal, which includes an amended and restated Reliability Support Services Agreement, or RSSA, would protect the reliability of New York State's electric system pending the construction of an implementation of needed system upgrades by ensuring the continued operation of the RE Ginna nuclear power plant during that interim period. The joint proposal was signed and is actively supported by Rochester Gas and Electric Corporation, the RE Ginna nuclear power plant, the staff of the Department of Public Service, the Utility Intervention Unit of the New York State Department of State, and multiple interveners. These parties represent a wide range of competing interests. If the joint proposal is adopted as proposed without material modification by the Commission and also by the Federal Energy Regulatory Commission, it would result in a global settlement at the state and federal levels. The joint proposal is opposed in part by the Alliance for a Green Economy and the Citizens Environmental Coalition. They claim that RG&E imprudently failed to plan for the potential retirement of the RE Ginna nuclear power plant, and that therefore ratepayers should not be asked to bear the costs of the joint proposal and the amended and restated Reliability Support Services Agreement. The proposed order before you would reject these arguments because although given a fair opportunity to do so, the Alliance for Green Economy and the Citizens Environmental Coalition did not make a prima facie showing of imprudence on the part of Rochester Gas and Electric Corporation. The signatories stress that the joint proposal is in the public interest and should be adopted, and I would note that the senior advisory staff of the department concurs with that recommendation. Signatories say that the 24-month term of the joint proposal is aligned with the time needed to implement the Ginna retirement transmission alternative, which is the long-term solution to the potential retirement of the RE Ginna nuclear power plant. They also assert that the joint proposal will assure just and reasonable rates. In exchange for the continued operation of the Ginna plant, Rochester Gas and Electric Corporation will pay Ginna $15.42 million per month during the effective term of the amended and restated RSSA. This will be offset each month by 70% of the revenues that Ginna gets from its sales of energy and capacity, and 100% of the revenues that it receives from its provision of ancillary services in markets, wholesale markets administered by the New York Independent System Operator. After the RSSA expires, RG&E will also pay Ginna a one-time settlement payment of $11.458 million. After accounting for Ginna's wholesale revenues, staff estimates that RG&E's total payments to Ginna would be $166.7 million. Ginna's total compensation would be subject to a floor of $425 million and a ceiling of $510 million. These limits correspond with Ginna's going forward costs and its full cost of service. These terms ensure that the joint proposal would protect customers from excessive costs and ensure that this agreement will be consistent with relevant orders of the Federal Energy Regulatory Commission. RG&E would fund its costs through two mechanisms. First, the company would implement a permanent surcharge, which would supplant the temporary rate surcharge that the Commission approved in August of last year. The new surcharge, designed to collect $2.25 million per month, will protect RG&E's cash flow, its credit ratings, and its access to capital markets. Second, RG&E would use up to $110 million in existing customer credits to pay down the costs of the RSSA. The signatories argue that this use of customer credits would be reasonable and will mitigate the bill impacts of the joint proposal. Staff in particular points out that when the Commission approved the temporary rate surcharge in August of last year, the Commission explicitly noted that the use of one-time credits to pay down one-time costs is a sound rate-making practice. The signatories also advocate that the bill impacts of the joint proposal would be just and reasonable. After cost offsets from Ginna's wholesale revenues and from the application of existing customer credits, RG&E's base rates would increase by just over $2 a month for a typical customer having a bill of about $95 a month. In summary, the joint proposal and the amended RSSA will ensure continued system reliability, pending needed system upgrades, ensure RG&E's long-term viability, and protect ratepayers from unjust or unreasonable rates. For these reasons, the terms of the joint proposal, including the RSSA, are consistent with state and commission policies and in the public interest. Accordingly, the terms of the joint proposal should be adopted. This concludes my presentation.
Thank you. First of all, I do appreciate the fact that the joint proposal does reflect a good balance of both the use of credits and the recognition that we also need to make sure that our utilities retain their financial health and their cash flow, because that also affects rates. So I appreciate the work of the staff and the parties, and I also want to note in particular in this case the concurrence of the FERC staff that they joined in on the joint proposal that's going to FERC, which is unusual and I think is indicative of the fact that folks work very, very hard to address the right balance of interest in this case. Certainly, this is a matter that the Commission had before us. We put in a temporary surcharge. I'm certainly in favor of moving to the permanent surcharge. I also read the record and do agree strongly that there is simply no evidence of imprudence on the part of NYSEG in this case, and I would struck me that if utility in the circumstances that they found themselves several years ago came to the Commission and said we want to build transmission because we think a nuclear generator may shut down because we think that gas prices may drop and we think that therefore it may become uneconomic, in all likelihood the Commission would have said thank you, see you later. So I doubt that we would have allowed them to go out and build transmission in that types of circumstances. Certainly things have changed in the market. We are encouraging utilities to take a look at risk generators so we don't find ourselves in this position, but at that time, I don't think anyone would have seen the downturn in the market in terms of pricing that we're witnessing today. So I clearly think there's no issue of imprudence. And with that, I intend to vote for the item. Thank you. Are there any questions? Commissioner Sayre?
I've lived in the general area of Gannett for the last 25 years on the east side of Rochester, and I can say that they've been a good neighbor to the community. If you're driving down Lake Road and you're not looking for the sign, you probably won't even notice that the plant's there. The main complaint that I hear about Gannett is from fishermen who can't get up real close to the plant anymore like they used to, where the slightly warmer water in that part of Lake Ontario attracts a lot of fish. But we have to blame the Homeland Security and Nuclear Regulatory Commission for closing that off to anglers. They provide 600 plus good jobs in a relatively depressed area of upstate New York, and I'm happy to see them continue to run.
Thank you. Commissioner Kapoor, Commissioner Berman?
I just have a question for Raj. Is this needed for reliability?
Yes, Commissioner. Based on the studies done by the ISO and RG&D, they are needed for reliability.
I have no further questions.
Commissioner Kapoor, any further? Right. So for item 304, third item, 302. All those in favor of the recommendation to adopt the terms of the joint proposals described, please indicate by saying aye.
Aye.
Opposed? And I want to do a particular shout out in case he's listening to Mr. D'Ambrosia, who's retired now, but I know was very instrumental in this case. So thank you. And for the hearing, no opposition, the recommendations are adopted. Going on to item 304, and that's in the matter of the implementation of a large-scale renewable program and clean energy standard. Paul Agresta, Deputy General Counsel. Welcome. Paul, please begin.
Thank you. If I ever manage to retire, I won't be listening in.
Yes, you will. You will miss me so much.
Item 304 is a procedural item that would expand the scope of the Clean Energy Standard proceeding to include the consideration of a program to provide expedited financial support to maintain the viability of certain nuclear power plants in order to not lose their zero-emission attributes. The staff white paper on the Clean Energy Standard issued last month already proposed that a tier be created within the CES mandate in the form of a separate obligation on load-serving entities to procure megawatt-hour production credits from qualifying nuclear resources. But in the brief time since the white paper was issued, two things have happened. First, the New York Independent System Operator issued a generator deactivation assessment of the Fitzpatrick nuclear facility that concluded that loss of the Fitzpatrick plant, along with a number of other plant retirements, including the Gannett nuclear plant, creates a statewide resource deficiency that constitutes a reliability need that would occur starting in 2019. The New York ISO has issued a solicitation for what it calls a gap solution to address that need through new or retained capacity resources. The second thing that happened is that the owners of the Fitzpatrick and Gannett plants have both indicated that the proposed CES mandate is not certain or timely enough to keep the plants open. Both of these plants are highly sensitive to timing, particularly due to their current fuel cycles and the need to commit financially and to procure a fuel supply well in advance of a running cycle. To enable more expeditious action than can be provided by the CES mandate, this program would be modeled on the existing Renewable Portfolio Standard Maintenance Program and be funded by the ratepayers of the 6 jurisdictional electric utilities in the same manner as the RPS maintenance program. The program would provide certainty in the form of short-term contracts, ensuring that the nuclear facilities receive revenues to support their going-forward costs necessary to keep the plants in operation until the CES mandate or other solutions can be implemented. If, after receiving comments, the Commission approves the expedited program, maintenance contracts could conceivably be put in place in the third quarter of this year. If confidence is provided to the New York ISO that one or more of these plants will remain open due to these maintenance contracts, the New York ISO may also be able to withdraw as unnecessary its request for a liability gap solution. But the action today is merely to expand the proceeding and put this proposal out for comment and further consideration. This concludes my presentation.
Thank you. So let me just add my observations to this. We are in a position now in the state, as the ISO has recently identified, that with all of the announced retirements, and that would include, lastly, the Fitzpatrick unit, but there are others as well, Dunkirk, Huntley, Gannett, and Astoria. We're going to find ourselves in a position as early, I believe it's 2019, Raj?
Yes, that's correct, 2019.
Where we would not have sufficient generation available to meet our obligation to have reserves to maintain the adequacy of generation in New York. From my perspective, I believe that we will be looking at the CES, and I'm fully confident that within the CES we will have a zero-emission standard, which will allow for us to address the issue that we have in nuclear power in upstate New York, the availability of resources that are able to provide zero-emission energy that's baseload and helps us maintain reliability and provide us a good transition to a future where we want to go in the state, which is 50% renewable by 2030. The difference, however, is that in the case of fossil units, they can announce a mothballing, meaning that they will temporarily shut down and then come back if the price is right. In the case of nuclear, that kind of flexibility is not there, and I think it would be a shame if we saw units retire because we have low prices because of a timing issue, only to find out we have either a new unit coming on to replace them that we might not need, or find out 4 months later that the clean energy standard with the ZECs would have met their economic needs and we could have met our concern, which is to have a good transition into the renewable energy standard and retain these jobs, such as the jobs we're talking about at Gannett, as well as the 700 jobs at Fitzpatrick. So with all of that, it just to me that what this order does, it provides the Commission an opportunity to say very decisively, we do not want to see a plant retire for want of a short-term solution to a longer-term opportunity, and that therefore we are going to take comments to see how we can address the near-term needs of the nuclear units so that they can get the confidence that they are going to be able to have the resources necessary so they can provide the clean energy attributes that we want in this state. The alternative is really probably more cost to consumers and certainly not having what we want, which is a diverse fuel mix that also includes zero carbon resources, particularly as we build out the renewable energy portfolio we want to have. So for that, I believe it's one of these, again, moments that we can act decisively. We could take steps forward. We can find a solution that really works for consumers and works for the market, and then give us all ourselves an opportunity to get where we want to go in a way that's least cost. So I intend to vote for it. Any questions or comments about this item, Commissioner Akinpur?
Paul, as you know, I was briefed on this. I asked the question, and I'd like it to be on the record. Is this a national problem?
Yes, it is, Commissioner. The markets that are designed by FERC do not look at environmental attributes. They only look at price. And due to the recent change in gas prices, where gas prices are very low, there are nuclear plants throughout the country that are threatening to close or are already closing. And it is a national problem.
Is FERC planning any action in the near future?
My understanding is that FERC feels that it may not, under its statute, distinguish between plants based on attributes and must rely only on price. And so my understanding is that they are not planning on taking any action.
I think it would be a good idea. Again, you know, I'm happy to work on something where New York will lead, but I think it would be imprudent to let the federal side of this issue get off the hook. And I really think that, you know, we need to stand up, write a letter to FERC along with our congressional delegates to let them know how we feel about this and that this is a national matter of interest. I mean, if it's an interest to New York, it's certainly an interest in other states, particularly those states that are now building new nuclear plants. What are they going to do? How does this affect them financially also? Raj, you know?
Clearly, there are two types of regimes in the country today. Those that have restructured markets like us, New York, or PJM, or New England, MISO, California, and Texas, and the others are still vertically integrated, fully cost of service based. This problem is acute that we are talking about in restructured markets where the generated revenues are dependent on the market prices. In the non-restructured states, the commission still have the ability to provide them full embedded cost of service. So some of those units, perhaps in Georgia or other places, they're still in the cost of service based. That said, your identification of it's a national issue is relevant in all these restructured markets where nukes are finding it hard to be financially viable.
Yeah, so I think, you know, it really is incumbent upon us while we're taking this action to kind of push the envelope further.
Commissioner Akinpur, I think, I mean, the challenge we have, and as Raj stated, if we had not restructured, and that's why, as you know, even in Ohio, they're looking at re-regulation for this very purpose, is that nuclear power plants that live in where you have fully integrated utilities, commissions are addressing this issue by simply allowing utilities to raise the rates. In a wholesale market, the generators are totally dependent on the market revenues. These market revenues are made because under the Federal Power Act, they have to be indifferent to the technology. So the fact that in New York, like many states, we worry about CO2, that's something that FERC is just simply does not have within its arsenal of tools to address. The other issue, quite frankly, we're all stuck on, and I hate to get into politics here, but the matter of fact is that the federal government sought to address this issue through the Clean Power Plan and looking at reduced emissions. As we all know, that Clean Power Plan now is stuck at a Supreme Court, which we don't know where that's going to end up. So in the meantime, New York has to act. I mean, we have, in fact, Governor Cuomo has joined many states in saying we're going to continue to implement the Clean Power Plan irrespective of what's happening at the federal level, and has also joined in with 16 other governors, talked about their commitment to clean energy. And so we are decisively acting and frankly telling Congress we would like to see something happen here or tell the federal government. But that gets back, I think, to our dilemma. We hate to see a nuclear power plant such as FITS, such as Ginna, which is in a region that it's in license, it's fully capable of operating, and would retire simply because we're not able to develop a process to address the fact that they are providing a valuable attribute to us, i.e. zero emission energy, in a time that they can then make a decision. So for all of that, I think that's why we're acting, but I definitely think that we in New York are speaking loudly and clearly that we're acting because we are missing a good clean power plan in this country.
I totally agree with everything that you've said, and I think it would be important to share what we've done with our federal representatives. I mean, we're doing something here, we're in the state, they're at another level. Sometimes they just don't know what we're doing and how important it is. So I think it might be a good idea to have some kind of a correspondence with them also.
We will. Thank you. Commissioner Sarah?
I have a question about cost to the consumer for Rush. Could you give us a rough estimate, rough comparison of the cost per megawatt hour that we are currently paying for new, fully renewable generation sources versus the estimated costs under this plan for a period of time to keep the nuclear plants afloat?
For the nuclear costs, the example would be the one you just approved a few minutes back on the Guinea Power Plant RSSA. So there, the costs were thoroughly examined by us and all the other parties and federal government FERC staff too. And the price in that contract varies. There's a floor and a ceiling. By the way, it's a pretty innovative and complicated proposal that you just approved. It may look simple, but it took a lot of effort and time for the parties to craft the settlement that Sean just presented. In that, the cost varies, but in roughly, I would say it's in the ballpark of about $49 a megawatt hour to $50 a megawatt hour expected price paid to Guinea effectively. And so when you say the cost, the way I would define cost here is what would they get in the marketplace compared to what are they being paid through this contract. So what they would get in the marketplace is a function of market prices, as we just said. Clearly, we know the historical prices. The future prices are estimates, and we do have futures markets to give us a clue as to what the price might be. For example, today we are in the range of maybe around $35 a megawatt hour, $36 a megawatt hour, all in, which is energy and capacity roughly in that location, in that area. These are all on an annual basis, as you well know. They vary by time and location, and so if you use those two parameters of cost of about $50 and price of, market price of about $35, that translates to roughly about $15 per megawatt hour, so-called above market price or out of market price. What have we been paying for renewables through our large-scale renewable program in the past auctions? They vary between $20 and $30 roughly, maybe around $25 a megawatt hour. So we are paying for the attribute there too, which is carbon-free emissions. So the nuclear out of market also we are paying, although the Guinea was premised on reliability considerations. Looking forward in the Clean Energy Standard, we are looking at carbon attribute pricing. So that provides you perspective for the nuclear. Although it's 15, it could be between 10 and 20, depending on the cost structure of the particular unit that may be. That we'll be looking at. And the renewables, as of now, it's in that range, $20 to $30. But future, we'll see what those prices are going to be as technology evolves.
But as of now, it's cheaper to keep the nuclear plants going than to for ratepayers.
Not only that's
new
true,
renewables.
yes, your observation is absolutely right. But also I would note that if you were to shut down a plant like Guinea, 600 megawatts or 850 megawatts of FITs, what does it take to replace equivalent amount of energy? Energy is big with these nuclear plants because they run 95% of the time. What type of renewable energy would you need resources? For a 600 megawatt Guinea power plant, you're looking at replacing it with maybe about 2,000 megawatts of onshore wind. So if you put it in context, in the last decade plus, in the RPS program, that's the amount of renewables that were developed, 1,900 megawatts. So it's not just the price, but just the physical ability to get those resources in place in a hurry is also a constraint. So for a 850 megawatts of FITs, you're looking at over 2,500 megawatts of equivalent onshore wind. And if you talk about solar, it'll be even much, much higher. So getting those resources in a hurry is not going to be easy, physically just not possible. So by necessity, you would be replacing some of them with fossil fuels in the near term if they were to shut down.
Thank you.
So I have a couple of questions. When we look at the ISO and their reliability assessment and the gap solution, my understanding is that the analysis that was done was that in 2019 we may have a reliability issue. Is that correct?
Yes, the latest assessment that the ISO put out in this month is with the potential retirement of FITS next spring. They're looking at resource adequacy violations sometime in 2019. And they compute what is called a deficiency amount, or how many megawatts would it take to replace to meet the minimum reliability requirements. That's about 325 megawatts or so.
So can we I just want to be, because I know people are listening. No, I just want to be clear. We always talk in terms of reliability, but there's two types of reliability. When we were talking in terms of the transmission, this is really system reliability. The ISO and that's the same issue we found with Guinea. It was actually the transmission system would become unreliable with the loss of that unit. The ISO finding, why we talk in terms of reliability, is really in terms of adequacy of generation, meaning that you have enough generation available at peak. And I think just for the point of people who are wondering why we're not looking at transmission, the issue is it's not a transmission issue, it's actually a generation issue.
That's absolutely right.
Thank you for that clarification. I think it's important from the beginning. For me, it's about reliability in all aspects and how things fit together. So when we look at solutions in New York, recognizing that we need to make sure that we're planning for the short and the long term, and working with numerous folks who might be able to help us with that planning, so that we are looking comprehensively and holistically. So for me, the ISO's assessment was one that I very much appreciated, because it gives us an opportunity to look at where the ISO is from a reliability perspective and an assessment perspective, moving out, not only in the here and now in a specific plant, but where we will be. And we had the State Energy Plan, which came out in 2015. Statutorily, it would have been 2013, but it was 2015. And so when we look to the next State Energy Plan, are we looking at 2017 or are we looking at 2019? Because are we going by the 2015 date? So then the next one would be in 4 years for 2019, or are we looking at going backwards? If you came out in 2013, would it be 2017? And I don't know if you know that answer.
You mean when the next state energy plan would be issued?
Mm-hmm.
It's the statutory, but why don't we get back to you on that?
We have to get back to you
Right.
on that.
So-
But on a reliability front, Commissioner, we always look out not just next summer or next 5 years, but next 10 years
Right.
planning
And the
horizon.
only reason I ask is I do think it's important, especially because a lot of, what has come with the clean energy standard has been because of the 2015 state energy plan. So for me, I want to look forward also to making sure we're all laser focused on the short and the long term, and the next state energy plan, which will help us in some of our formulations. And especially if the 2019 is the state energy plan versus 2017, then at least we sort of have a pathway in terms of working through what some of the reliability pieces may be, as well as the clean energy. And, I look at it as, we need to, focus in on a lot of what we have done and where we're going, and make sure that we're on the right pathway, with the transmission needs, as well as the natural gas needs, as well as the renewable needs, and make sure that, all the relevant entities are working together and also on the same target dates, but also checking in with what this means now with the gap solution, because I do think that it's important to have conversations with key entities in the state that could help us in a lot of our detailed analysis that we need to do. So, from my perspective, I think it's just important to clarify that I'm really looking at this as what is the pathway, short-term and long-term, and making sure that we're not doing things in a silo, but that everything is sort of fitting, and then we go back and make sure that we look carefully at how things now get reset if necessary, so that things do have an understanding of where we're going. And so I understand that, there is a national focus, and I also want to drill down on what we're doing specifically in New York with all of our relevant plants and all of our relevant energy sources, upstate and downstate.
I appreciate that. I think that, you're talking about the state energy plan. I also want to note, though, that, and we expect that to be delivered soon, we are, working with the ISO and the utilities in developing actually a resource outlook for what the transmission needs will be and the system needs will be under various scenarios going forward, which is, I agree with you, having that in mind, understanding not just what we need today, but what we're going to need over the next 10 to 15 years, because it takes a long time to develop these systems is really critical, and looking at it under various types of complement of resources. The other piece that I know we're all keen on is also thinking in terms of what's the fuel mix going to be, and making sure that we're looking at it on both the reliability of the entire system, so that we're neither underbuilding or overbuilding these systems.
Great, and thank you for reminding me on the resource planning, because our July 2015 session, where we looked at moving things to the ISO for planning with our generation and our transmission needs, I did reference in my concurring statement that I hoped that the resource planning would come back and to the Commission for some weigh-in as well. So I do appreciate that.
And we'll get an update to all the commissioners of where we are in that process.
Great, thank you.
So if I can, let me move then on item 304, which is in the matter of the implementation of a large-scale renewable program and clean energy standard, and the recommendation to expand the scope of that proceeding to include the expedited program to maintain the viability of nuclear power plants, demonstrate need. Please indicate by saying aye.
Aye.
And I concur only to the extent of agreeing to initiate this new aspect of the proceeding to open the dialogue on this issue, and it does not indicate I've made a determination one way or the other with respect to the substantive outcome on the future actions on this matter or any other related matters.
Okay. I'll accept that as also in support, and I believe that we, all of us are in that position. So with that, and there being no opposition, the recommendations are adopted. Thank you. I want to move on to the consent agenda. Do any of the commissioners wish to recuse from any items on the consent agenda? No, hearing none. There are any comments on this consent agenda?
I have concurring statements on 5 different items, which I'll read, and then if you want to take a vote on the whole.
Read this.
My concurring statements, yeah.
Sure.
On item 365, I do note, I concur on this item, and I do note that we have a number of outstanding proceedings that concern resolution of various net metering matters. Normally, I would seek to resolve such issues together and not in a piecemeal fashion. However, this specific issue relates to administrative billing matter that, due to the upcoming effective date to start such billing, needs to be resolved now. I support approval of this petition request for the reasons cited by Central Hudson, especially because failure to grant such request would cause unnecessary time and expense to be incurred. On item 369, I concur on this item. I do note that we have a number of outstanding proceedings, again, that concern resolution of various net metering matters. This is one of several... Hold on, I lost my place. This is one of several declaratory judgment petitions that have been brought seeking regulatory clarity on remote net metering. Normally, I would seek to resolve such net metering issues together and not in a piecemeal fashion. However, this specific request relates to the immediate need for certainty on a specific fact pattern related to remote net metering. I'm concurring here to give such clarity, but I do note the need for the Commission to carefully examine issues that have been raised on how far to extend the remote net metering participation of various entities and site-specific locations. On item 375, I concur on this item only to the extent that I approve the release of the draft SEIS for public comment and wholly without prejudice to any future substantive issues set forth in the draft SEIS document that will be presented in the future to the Commission, including approval and adoption of the final SEIS and any regulatory action that the Commission may be called upon to render on the clean energy standard. Item 461, I concur on this item. New York American Water has been actively acquiring several small water companies in New York. This is not a bad thing, and in fact, such acquisitions may be helpful, not just to New York American Water, but to the troubled small water companies and their customers and to the impacted communities. On August 8, 1994, in case 93-W-0962, the New York State Public Service Commission issued a statement of policy on acquisition incentive mechanisms for small water companies. This policy was to encourage the acquisition of smaller troubled water systems by larger systems and included a number of options to provide incentives for such acquisitions. The stated policy of consolidating where appropriate the industry had the goal of thereby achieving safe, adequate, and reasonably priced water service for the long term. On December 17, 2015, this Commission commenced a proceeding in case 15-W-0562 to review this policy and look at the landscape of what was happening in this area. That generic proceeding is ongoing. The final decision we may make in that generic proceeding can have a significant impact on how we move forward on such acquisitions and provide consistency in achieving our policy objectives and impact positively our actual water systems. Normally, I would not want to decide this type of specific proceeding while we're still examining our policy in the ongoing generic proceeding. However, I'm cognizant that here we are concerned with ensuring safe and adequate service and the long-term viability of the source supply of the water system. Thus, I support approving this acquisition at this time. I do want American Water to keep us informed on the water system and the status on the immediate and long-term infrastructure issues. I also look forward to the resolution of the ongoing generic proceeding. Item 464, I concur on this item. Under Public Service Law, Section 89-B, the Commission is required to ensure regulated utilities provide safe and adequate service at just and reasonable rates. Further, under Public Service Law, Section 89-C2, the Commission has the power to examine and investigate the methods employed by waterworks corporations in delivering and supplying water and furnishing equipment. Here, it has been brought to our attention that we need to address concerns with whether safe and adequate service is being provided. I'm cognizant that on August 8, 1994, in case 93-W-0962, the New York State Public Service Commission issued a statement of policy on acquisition incentive mechanisms for small water companies. This policy was encourage the acquisition of smaller troubled water systems by larger systems and included a number of options to provide incentives for such acquisition. The stated policy of consolidating where appropriate the industry had the goal of thereby achieving safe, adequate, and reasonably priced water service for the long term. On December 17, 2015, this Commission commenced a proceeding in case 15-W-0562 to review this policy and look at the landscape of what's happening in this area. That generic proceeding is ongoing. The final decision we may make in that generic proceeding can have a significant impact on how we address small water companies and provide consistency in addressing any concerns with safe and adequate service with our actual water systems. Normally, I would not want to decide this type of specific small water system while we're still examining our policy in the ongoing generic proceeding. However, I am cognizant that here we are concerned with ensuring safe and adequate service. Accordingly, we must act now. Thus, I support approving this item at this time, which will take immediate steps to ensure safe and adequate services being provided and to keep us informed on ongoing issues. I also look forward to the resolution of the ongoing generic proceeding. Thank you, Chair.
Thank you. Before we vote on the consent, I do want to mention that on our consent agenda today, there are two items, items 363 and 373. We already, thank you, Peter. There are two items, 363 and 373, and these are essentially companion items to our the proceeding that we had voted on already regarding the Auburn transmission. And just want to note that with respect to item 363, and that is the acquisition of the Cayuga plant, the order is in favor of the acquisition. We are, however, the order recommends that we do not approve the repowering of the Cayuga resources, finding that that is not in the public interest. So just to be clear, and we are not suggesting that Cayuga could not repower on its own, but what we are finding that it would not be in the public interest, not be in the interest of NYSEG ratepayers to pay for that repowering because it is more expensive and not needed in light of the fact that we do need transmission regardless. So with that, I'm going to move to vote on the consent agenda. All those in favor with the comments made by Commissioner Berman, please indicate by saying aye.
Aye.
Opposed? Hearing none. The consent agenda is approved. Is there anything else before us today? Secretary Burgess or Commissioner Burgess, if you, but that would be a demotion, so.
There are no other items today, and the Commission's next session will be March 17th in the Albany office.
Great. Thank you. Thank you all.